lights, camera, action gives a whole new meaning.
All right, welcome to another episode of Beneath the Law, and I'm joined by my colleague and good friend, Gavin Tighe. Gavin, how are you doing?
Stephen Thiele, I am as good as can be expected I'm actually really good. It's almost St. Patrick's Day, my favorite day of the year, and things are good.
That's because you're Irish.
That's everybody's Irish on St. Patrick's.
We're all having green beer and green milkshakes on St. Patty's Day.
Not in that order, because that can lead to a lot of trouble.
It can.
Oh, this is a spicy episode today, Stephen. I got to tell you, very spicy.
It's a story about a sex tape, but let's lead in, first of all, what this is really.
A story about a what?
About a sex tape. And how a sex tape landed in court and created a bit of a legal issue with respect to the doctrine of absolute privilege.
Interestingly, before we go, it's not your run-of-the-mill sex tape, though. This is a surreptitious sex tape, in the sense that it's not the ones where we've seen in other instances where people actually do these things, like do their sex tapes voluntarily, knowingly, for whatever reason. But this was a sneaky sex tape.
It was a sneaky sex tape involving family or former family members and a new girlfriend. But let's talk first of all about the doctrine of absolute privilege. You know, we have different episodes, and this one is fairly legal, so the doctrine might be a little bit dry for folks.
Yeah, but it's in a good kind of spicy setting. It's dry and juicy all at the same time.
So the doctrine of absolute privilege protects defendants in certain circumstances where, defamatory words or conduct in a quasi-judicial or judicial proceeding are made, and a defendant basically raises this doctrine as a form of immunity and can strike a claim. And so this sex tape was provided to the court in a mandatory case conference, and the plaintiffs, who were the subject of the sex tape, a man and a woman, decided to sue the lawyers who circulated this tape.
We should probably put that in context. It was what would apparently be described as an extraordinarily acrimonious family law dispute, where husband and wife had separated, but still lived in the same house together.
Maybe they were saving money.
Well, they're definitely saving money, but with whatever money they saved, apparently the now ex-wife spent on secret video cameras, which she installed in the ex-husband's bedroom.
Yeah, in the house, and started recording things that were taking place.
We all get what was taking place. Shortly after the demise of relationship 1, had relationship number 2. And it really, it's like, man, dear girlfriend, hey, you want to come back to my place with my ex-wife, my kids? Anyways, apparently the answer to that question was yes, and back they went. Little did they know that there was that eyes were watching, and that the secret camera was videotaping.
Was rolling. Absolutely.
It was lights, camera, action. That gives a whole new meaning. Anyways, I didn't really understand this point, though. I mean, like, we kind of live in a no-fault divorce universe. So who cares if, like, they're separated, spouses getting it on. What's it to you? I mean, what difference? Why was that relevant?
I think that's the entire point of why the plaintiff sued both the ex-wife, or, in the case of the girlfriend,
the ex-wife, who's sneaky ex-wife who is planting cameras in bedrooms. That's kind of icky when you think about it.
Well, it's very creepy when you, as you say, think about it. That's like we've got now in Ontario, we've got a janitor who's just been charged with multiple counts of voyeurism for setting up a hidden camera in a woman's washroom. Right?
Yeah, but this is as creepy. Maybe it's not. That's pretty creepy. It's on the creep scale. Let's put it that way. And I guess I don't know what was she looking. I guess she knew. I mean, the bedroom was in the house. She's living in the house. I mean, I don't think it's a big secret of what's happening in the bedroom. And I suppose she wanted to have a record of it for whatever reason.
But you're right. There's absolutely nothing to gain in family law if a spouse is having an affair and that causes the breakdown of the marriage, because we live in a no-fault kind of divorce and family law universe now. And
did it go to a custody issue? Was there some argument about the kid? I don't know enough about the case, but I mean, was it relevant to the custody of the child?
Well, and that's what the plaintiffs argued, Gavin, that it was irrelevant, that there were parenting issues that this case conference was supposed to deal with. Perhaps the ex-wife was thinking, well, if he's having, sex with some girlfriend, that
he's not watching the kid.
Yeah, that makes him a bad person in terms of being a parent. I mean, so it was a little bit not understandable. And even the court said that the sex tape being circulated, and remarkably, the lawyers circulated that tape to the lawyers who acted for the kids in the family law proceeding.
The kids had their own lawyers?
The kids had their own lawyers.
Wow.
And so
they would really need to be saving money. And no wonder they were living in the same house. How many sets of lawyers do they have to pay?
We know at least 2 or 3.
And still have money to afford secret cameras. So, yeah, maybe they would have been better off to save money on some lawyers and technical equipment, rent an apartment. But in any event, the issue, as I understand it, of absolute privilege attaches to the fact that the tape was distributed by the lawyers within the confines of the legal proceeding. And that, I think, is the point, is that you cannot, generally speaking, sue in another lawsuit for what happened in one lawsuit, right? So I can't, for example, if somebody's testifying at a trial and they say something absolutely defamatory in their testimony about somebody, then they can't be sued for that because it's testimony within a court proceeding. They couldn't be sued for that defamation. The court could find that they're full of it and that they lied or that they perjured themselves, but that's an issue within the context of that lawsuit. It's not a separate proceeding, is it?
Yeah, and it's not. And oftentimes, Gavin, our affidavits are very aggressive, and you'll raise issues with respect to the other side that will, strike at the heart of their credibility or their reputation, and file that within the court. And that's all protected.
Well, what goes on in the arena of a lawsuit remains in the arena of the lawsuit.
Now, this was an appeal decision. The
Right.
judge at first instance, Gavin, did not strike the claim because the judge at first instance believed or found that there was an exception within this immunity defense that did not protect gratuitous or irrelevant conduct or evidence. And so that's what they found. They relied on another lower court decision that had found that there was this exception.
Well, that's an interesting issue right in and of itself to my mind, because number one is I can see what if you are simply using a frivolous lawsuit, for example, to build yourself a soapbox to defame somebody. And then your lawsuit gets dismissed, whatever. But you've already done the harm. I mean, surely I think that would be an abusive process if it were found that you never had any bona fide belief in the merits of the claim, and you brought it purely to give yourself a platform to harm somebody. I mean, would that not get around this absolute privilege issue? Or would it, in the sense that it's malicious?
Well, I don't think it would. We've seen defamation cases where people have acted with malice, or, even frivolous cases. I think in that context, Gavin, the person bringing that kind of lawsuit would be embarrassed by the judgment alone, because
maybe they don't care. We see this. I mean, I've seen it numerous times with, plaintiffs who are maybe, not going to the top floor in terms of they're slightly deranged, and they're bringing crazy claims against all sorts of people all the time. And we've seen vexatious litigants, for example, declared vexatious litigants who are suing people, regularly for crazy claim, all sorts of crazy things. And they're allowed to say those things in the context of the lawsuit about their absolute privilege. But what if they know they're not true and they don't care? They're just doing it to harass people.
Yeah, but you're going to get a cost award as a defendant in that kind of a case anyway. So,
Yeah,
in some respects, you're protected in that regard.
And the vexatious litigant rules would enable that. So just for listeners who aren't familiar with that, the court can, in Ontario at least, you can bring an application to have somebody barred from issuing lawsuits if they are declared to be a vexatious litigant. And, well, they can bring legitimate lawsuits, but what they need is permission. So they need leave of the court to sue people, because we've had cases where people have literally issued, dozens and dozens of lawsuits against all sorts of people just to cause them grief. And, the court doesn't want to be used as a weapon of harassment.
No, and you have basically in a lot of those lawsuits too, Gavin, where those claims are basically repeats of judgments that have already been rendered. So people are trying to collaterally attack those judgments. But I just find this case quite remarkable in terms of, here you are as a lawyer, you get a sex tape in a family law proceeding that really shouldn't have any bearing on the issues before the court. And then you distribute that tape knowing that it was surreptitiously taken in the privacy of somebody's bedroom. Why would you do that as a lawyer?
Well, I hate to say this, and I don't mean to, cast aspersions, but in my experience, family law disputes can sometimes escalate and, to the point of having precious little to do with the actual merits of the proceeding. And it just turns into, the domestic strife that led to the family law dispute just sort of is carried out through the legal proceedings. And it's just sort of this nasty, I always want to hurt the other person. So, I don't know. I mean, I can't speak to this. I don't know the lawyers involved. I don't know the people involved, but it sounds like it was vitriolic in the sense of that they were just putting it out there to put it out there. And meanwhile, the girlfriend, of course, she wasn't even a party to the family law dispute.
No, she's really to me, an innocent victim of the ex-wife's conduct in terms of making the tape and distributing it. And look, I think there was certainly some emotional harm that was suffered by both the ex-husband and the girlfriend. And that's the reason that they've sued. Look, we see it in Ontario. And Gavin, you've had cases involving people with cameras taking, video of people in alleged private.
Supposedly.
Right.
Allegedly. And just so a quick background, of no names involved, but the hypothetical case that we're talking about involved, people will know that sometimes that there will have, real estate marketing, and they'll use drone footage of a property to market the property online or what have you. And in this particular instance, it was a condominium, and there was a drone footage of the building and, flying around, and, very pretty slick looking production. And somebody claimed that the drone footage included a vignette of them in flagrante delicto. And try as we may and try as we might, we couldn't find it. But they swore it was there. It was. Anyways, and they sued for invasion of privacy on the same basis. I mean, that would be, the typical type of claim. I just parenthetically, I do find it ironic in this case. The names of the parties aren't sealed. Like the sex tape issue, I would have thought the harm of it was in its existence and its promulgation and being publicized. We now have a reported case with the actual names of the people involved. So everybody who wants to know, online, you can find it. It's an Alberta case, and it can be found, by anybody who wants to search the names, one of them which is a little unusual and probably quite searchable. The actual court case, in a sense, hasn't it achieved exactly the harm that the plaintiff was seeking to avoid? They're more famous. We're talking about them. They're on a podcast. We're talking about them. They're a reported case. There's lots of people are going to be talking. Whereas if the idea here was to keep this quiet and sort of, minimize the harm done. I mean, now everybody knows there's a sex tape and basically the circumstances of it, other than not seeing it, but we can think much of an imagination. We all know what happened.
Yeah, but
Isn't that?
but we're all subject to the open court principle anyway. The plaintiff sued.
Which is exactly my point. So I think the things that people need to think about, and often think about, and we hear about it in defamation cases as well, is you got to be careful sometimes that you don't give the other side exactly what they wanted in the first place by suing them. I mean, hasn't the wife got her, what she was after, which is the notoriety and the kind of it's a revenge porn kind of attack? She's got it. She's made us famous. Now the girlfriend, there's a sex tape of you. I mean, the girlfriend kind of ironically gave the wife what she wanted. Or you're not convinced?
No, I'm not convinced, Gavin, because at the end of the day, it's still an invasion of privacy.
Invasion of privacy.
And so,
but now it's a very public one.
Okay, but I'm going to raise this issue. Was the wife's conduct to such an extent that she's actually committed a criminal act? Is there not a voyeurism aspect to this? Like, I don't know if she's been charged in
Why is
Alberta.
she any different than the janitor?
Well, exactly, right? You're setting up a hidden camera in, let's face it, isn't the bedroom the most private place? Like, there used to be the statement that keep everything private, leave things in the bedroom. Why are we bringing things out into the public on the political side?
Yeah, well, it was Pierre Trudeau, wasn't it, that the state has no place in the bedrooms of the nation?
Well, there we go.
His famous quote. Yeah, 100%. And I mean, the reality of it is, it was clearly intended to invade privacy. There was a clear intention there. And as I understand matters, the girlfriend's claim against the wife is proceeding. Is that not true?
Yeah, the claims against the wife are proceeding because it was only the wife's lawyers who sought to strike the claim. Now, the other theory that the lawyers used to strike the claim was they owed no duty of care to the ex-husband and the girlfriend, and the court agreed with that. And we've seen that in a number of cases. That the opposing lawyers do not owe a duty of care to the opposing party.
And we've argued that in a number of cases that there's no duty owed to the other side in a lawsuit. And, when you step back and think about it, and the argument we've made, which has been accepted on many occasions, is that if there were, you'd be in a conflict of interest on every case. If I owe a duty to the other side, I'm in a conflict to my own client.
Yeah, and look, the lawyers, although they're successful here, the one question that I have, and again, I haven't seen it and I don't know what's going on, but did they breach the rules of conduct under the Law Society rules in Alberta?
I think to me, it smacks of sharp practice. It's not dissimilar to you got something, by accident, or an email was sent to you by accident or something that enclosed some privileged communication. And then you seek to take advantage of that slip on the other side, and use it against them. That's sharp practice. This is even worse because you've set it up. You've set up the surreptitious recording for whatever purpose. And, look, the wife may have said to the lawyers, I don't care. You use every weapon you've got. I want to hurt this guy. I hate his guts. But lawyers have a duty to kind of, be the brakes on this kind of thing sometimes. So, you know what? You may hate your husband all you want, but I'm not going to step over that ethical boundary. And, I'm going to conduct this in a reasonable way. I mean, I think as a lawyer, you have a duty to pull the client back. I think, unfortunately, in the world we live in right now, it's, we live in a competitive environment for lawyers as much as anybody else. And some lawyers seem to be prepared to do whatever their clients tell them to do. And that's not appropriate. Lawyers have a duty to sometimes say, you know what? I know you want to do that. It's a bad idea for the following reasons. This was clearly a bad idea. It didn't help her. It didn't help the wife's case. And it's created this whole fracas. But I think they needed to say, you know what? You may want to do that, but if you want to do that, get another lawyer. I'm not going to do it.
Well, no. And look, I take to heart the comments of the appellate court judge who said that it was basically ill-considered to have distributed this tape of the ex-husband and the girlfriend. We don't know if the case doesn't tell us what happened at the case conference. So that's not clear. We know that the plaintiff sued and tried, I guess, to raise the code of conduct as part of the plaintiff's claim. In general, a breach of the code of conduct does not lead to liability, but it certainly does potentially lead to discipline of the lawyers. And it seems to be very close to the line, if not crossing the line, of raising a vigorous defense or vigorous advocacy, right?
Yeah, I mean, we've talked about that before as well. I mean, in terms of, costs can be awarded against the lawyer personally when they cross that line, being a vigorous advocate to being, an unethical advocate, or that they cause costs to be incurred unnecessarily. I will say that would, to me, have been the more appropriate remedy, because what you would say is, you know what, all of this kerfuffle about this tape was completely a waste of time and money. This motion should never have been necessary to exclude this evidence because you should never have sought to admit it. And therefore, you have caused costs to be incurred unnecessarily through what is borderline, if not borderline and over the line of unethical conduct. So, lawyer, guess what? You're going to pay for it. And I'm going to make an order that the costs associated with the striking of this evidence are the personal responsibility of the lawyer, and or that they're shared with the client personally. That I think would have been an appropriate remedy.
Yeah, that certainly would have been an option available, I suppose, to the plaintiffs, for sure.
And it would have, and I think that would have had a salutary effect, because I think that, while I, at the same time, am a no fan of costs against lawyers being granted too easily, because I think lawyers do have to sometimes stick their neck out a bit and stand up for clients and take unpopular positions and do all of those things. And I think the court should be very, very guarded in terms of making this work. But when they do step over that line, when they do cause costs to be incurred unnecessarily because of, going way too far on the pit bull routine, then I don't think there's anything inappropriate with that. I think that, you follow the money. And if the cause of the cost being incurred is, the lawyer should pay for it.
Well, look, the rules exist exactly for that purpose. We don't know in terms of whether there's any disciplinary complaint that has been made against the lawyers. We're just speculating and talking about options that could happen. But that's why we have a podcast, that if you're not above the law, then everybody's beneath it, right?
These are the issues we talk about. I will say that one, just as a final epilogue, the damages, as I've seen, for breach of privacy are pretty small. I mean, there was the one where the ex-wife was going through the girlfriend's bank statements because she was I think it was a Bank of Nova Scotia case, I think the damages in that instance were somewhere in the neighborhood of $25,000, which is peanuts. So we'll see where this one ends up. But as you say, if no one is above the law, everyone is beneath it. Please rate us and subscribe anywhere you get your podcasts.